Good afternoon. We wanted to inform you that pursuant to instructions from our client, that is Babu Owino, we have just filed a revision application which touches or seeks to review the bond terms that were given. Indeed, the bond terms are quite hefty for any person or by any measure or standards. And as such, we are seeking a review from the High Court so that the High Court can actually revise those bond terms to levels that he can afford. He has partially met them, as you know. The bond terms were actually supposed to be met in installments, and I believe that is pursuant to the magistrate's appreciation of the high amount that was imposed. So he has partially satisfied that. He is out on bond. Nonetheless, it is also his right based on the fact and ability of meeting that particular amount that was given. We have also, pursuant to instructions, filed an application which seeks to stop the Director of Public Prosecution or any other officer acting or working under him from publicly commenting on this particular case. You rightly saw yesterday the Director of Public Prosecution lamenting, protesting against the decision of the court in public. In law, we have a principle whereby you should not actually comment, and especially touching on the merits of a matter that is in court. What he did yesterday is actually an affront to the provisions that guard against that and also protect the court itself and the dignity of the court. But more so, those particular attributes that he actually made also infringes on the right of our client, on the presumption of innocence. As you know, the public has taken it in stride and actually believe in terms of what he said, and that stops being prosecution. It is actually persecution. So all we are seeking from that court, because it is the court that is being put into ridicule, is for the court to actually take this particular step and stop any further actions or utterances like that from the Director of Public Prosecution in a bid to protect our client. That is the gist, the long and short of that. However, you should also know that the Director of Public Prosecution already filed a revision. He requested for review even before these ones. So we believe there are two review applications which will be before the High Court dealing with almost the same matters, even though our application principally is based on a revision of the amounts and also part of the finding of this particular magistrate in as far as compelling reasons are concerned based on the Constitution. That's the long and short of it. My colleague will actually address you on the other part of it.
Gave a very stinking and terrible statement yesterday, indicating that all his life he has never seen or heard a judgment or a ruling of that which came out in Babu Owino's case. We have raised those questions because there is nowhere in the law that judgments must be given to the DPP to approve, rulings must be given to the DPP to approve before they are read. The DPP's role is prosecution, and therefore, if he himself has never had such a ruling, it does not make that ruling an illegality. Presidents, for the benefit of the citizens of this country, presidents are set by judgments who will always, judges and magistrates who will give new decisions that have never existed. That becomes the law. So the DPP needs to be briefly told that what the Honorable Magistrate did is a novel decision, payment of bond in terms of installments. That should be taken up by all other courts, and every Kenyan support it, that instead of people being jailed because they cannot raise 10 million once, they be given time to pay. After all, the congestion we have in prison is because people are supposed to pay the fines instantly. What is wrong if a country like Kenya can take a loan from China and pay in monthly installments? If a country can do monthly installments, why can't now we discuss this further and say cash bail and other things can be paid in installments? Secondly, the DPP raised the question that the ruling is illegal. Remember, when the DPP mentions that a ruling is illegal, he is insinuating criminality. We are alive to the fact that the DPP at one time has arrested a judicial officer in Mombasa for making a decision. And that judicial officer was arrested and was charged until the courts came and found out that a decision of a magistrate, a decision of a judge, can never be an illegality. So is the DPP preparing ground to start arresting judicial officers who make decisions that don't please him? That is the situation we are asking the High Court to pronounce itself. No decision of a judicial officer is going to be declared an illegality. The DPP's only recourse is to appeal against that decision. Pursuant to that, in our application, we have enjoined the Kenya Magistrates and Judges Association, where the magistrate who is being called that he has committed a crime to be enjoined in our matter, so that they are able to raise those issues. Article 232 of the Constitution does not vest criminality on any public officer who makes a decision pursuant to his role as a judicial officer or as a public officer. Nowhere has anybody sued the DPP for making decisions to charge anybody. There is no criminal aspect. The DPP, pursuant to Article 157, exercises its power to decide who to charge. The magistrates, pursuant to Article 165 and other provisions of the Magistrates Act, will make decisions independently. So we feel that the DPP needs to be stopped, because this is a similar matter that we saw in the Mombasa drugs matter. Lastly, we have great exception, sensitivity of the state. In hospital lies a dying man. His bill, as we speak, is more than 3.5 million. The state is not coming up and saying they will pay that bill. The state seems to be, and the DPP's office seems to be waiting to celebrate the death of the victim, and therefore charge our client with murder. We feel that the state is being insensitive to the plight of the DJ. We feel that the family is being aggrieved because they are seeing a direction where selfish interests are being taken contrary to the life of a young man who needs to be alive. We urge the Kenyan public and everybody to first of all preserve life. Is the DPP and the state concerned more on the life of the victim who is lying at Nairobi hospital? That could be the issue. The court at the magistrate's court was very sensitive to the preservation of life. And therefore, that is why we have filed those two applications, one for revision, one to challenge the DPP, and one to raise other issues, as my good friend has said.